talks over the course of the academic year, you will get a certificate. If you attend 10 or more, you'll get a certificate of honor. And after each of these lunchtime talks, we do a draw, and you're eligible to win a book. And the draw is done on a random basis. I'm very pleased to welcome 3 contributors to the book that's available here. Michael has provided us copies from New York Bookstore on the criminalization of migration, and I'll introduce them shortly. But some of you might be wondering, what is the criminalization of migration, or that other special term called crimmigration? And it's really the merging of criminal law and practice with immigration law and practice, in essence. But I'd like to quote from Crimmigration Law, which was published in 2015 by Cesar Garcia Hernandez, who describes it as follows. Generally, crimmigration law refers to the intersection of criminal law and procedure with immigration law and procedure. The broad outline can be filled by the details of 3 trends that dominate the evolution that criminal law and immigration law have undergone in recent years. Criminal convictions now lead to immigration consequences ever more often. Violations of immigration law are increasingly punished through the criminal justice system. And law enforcement tactics, traditionally viewed as part of one or the other area of law, have crossed into the other, making enforcement of immigration law resemble criminal law enforcement and turning criminal law enforcement into the semblance of immigration law enforcement. Now, I should probably tell you a little bit about the origin of this particular volume. It started with CARFMS, which is the Canadian Association for Refugees and Forced Migration Studies. We had a conference at Ryerson University about 3 years ago, May 2015, and I was on the program committee at that time, and we were looking for a central theme for that conference, and we suggested the criminalization of migration. Eventually, the title of that particular conference became the following: the advancement of protection and fostering belonging in the global era for the criminalization of migration. And the co-editor of the volume and I agreed to select some of the best papers and invite them to form this volume that's now before us and available. So it was a 3-year publication project from conception right through to completion. And a brief description of the volume itself. It's composed of 12 chapters. There's a foreword, introduction, and conclusion. So there are 14 original contributions. 3 of the people that have contributed to the volume are here today. The volume is broken up into 4 parts. The first part is on the criminalization of migration and its intended and unintended consequences. The second part is the criminalization and the exclusion of refugees in Canada and abroad. The third part is the crimmigration responses to migration crises, historical and comparative perspectives. And part 4 is the criminalizing refugees and other forced migrants, current dynamics, future challenges, and prospects. So we're eagerly awaiting the book reviews. I'm sure they'll be out fairly shortly. But I can tell you it was a most satisfying project. I know it was quite long. All of the contributors can certainly attest to the fact that we had to go through multiple stages of peer review and so forth before the volume was finally accepted by McGill Queen's University Press. So let me briefly introduce the 3 presenters here today. I'm going to start with Joseph Rikhof, which is right next to me here. Joseph Rikhof is an adjunct professor in the Faculty of Law, the Common Law section at the University of Ottawa. He's recently retired, about 2 years ago now, from Justice Canada's Crimes Against Humanity and War Crimes section. Nancy Weisman is the senior counsel of the Immigration Division of the Immigration and Refugee Board of Canada. She's an alumnus of York University's Osgoode Hall Law School, and I've had the great pleasure of working with Nancy at the Immigration and Refugee Board for 11 years. And I relied very heavily on Nancy's legal advice, both on procedural matters and substantive refugee law. And when I didn't follow her advice, the federal court let me know about that. And then finally, Angus Grant. Dr. Grant is also an alumnus of York University's Osgoode Hall Law School, where he taught for a number of years. Recently, Dr. Grant was appointed to the Refugee Appeal Board of the Immigration and Refugee Board of Canada. When he wrote his contribution to our volume, he wasn't on the Immigration and Refugee Board of Canada. But it's been my great professional privilege to be able to work with all three of these particular individuals in various capacities over the years. I'm welcoming all of them back to York University. Two of them are fellows of McLaughlin College. Angus, are you a fellow yet? No. Well, we'll have to deal with that. So, welcome back to McLaughlin College. Thank you so much for your contribution to this particular volume. We've agreed to actually, I think, present in the order that the people are sitting here on the panel, starting with Joseph Rikhof. So thank you. Please join me in welcoming you here today.
Thank you very much. Before I'll start talking a little bit about the chapter that I've written for the book, I'd like to sort of follow James about his introduction about what criminalization of immigration is and how I think the three of us are contributing. Without going into much detail about the definitional parameters and philosophical underpinnings of this area of the law, I think broadly you can say that there have been two types of criminalization discussed in the book. The first one, at least that is my interpretation, please correct me if I'm wrong, all three of you, is that there are a number of provisions in the Immigration Act, either in Canada or abroad, which have dealt with what I call innate criminal behavior. Criminal behavior that has been recognized around the world by criminal codes as being inherently criminal. If you commit a murder, whether you do it in a criminal context, in a refugee context, immigration context, that is a criminal behavior that, in my view, should be addressed no matter what criminal system you deal with. That's one area. And that is an area that I will have discussed in my chapter, and so I think my so has Nancy in her chapter. So I'm going to talk about one of those aspects of the criminalization of what I indicate as inherent criminal behavior. On the other hand, what you see more and more the last decade is that behavior that is not innate criminal, governments around the world have decided they're going to make it criminal for the purposes of enforcing immigration. And that's a whole different kettle of fish in my view, because if you say that, for instance, somebody comes to Canada and the person has not followed the correct procedure and therefore will throw you in immigration detention, that doesn't mean the person, especially a refugee claimant, has followed the correct procedure, but all of a sudden the government or governments, it's getting in some respects both the words, have decided from now on we decided this normal behavior, which we didn't attach any consequences to before, now it's going to be a criminal aspect of it. So that is to me a different kind of criminalization which falls outside the inherent criminal behavior. And I think that in some respect, if I may say so again, Angus is addressing, at least in your chapter in the book. So, as I said, Nancy and I discuss aspects of the innate criminal behavior. And the way that we do it is we look at an aspect which is contained in the Refugee Convention, as well as in the Canadian Urban Immigration and Refugee Protection Act, and it's called exclusion. Exclusion means that if somebody who claims asylum or refugee status, that person can be refused any refugee status because of criminal behavior that the international community, after the Second World War, already decided those kind of people are not deserving of refugee status, no matter how much persecution they might have faced or will face in the future. That criminal behavior was seen as so severe that when we decided after the Second World War, those people do not deserve refugee status. Now, having said that, in Canada and other countries, people who are refused refugee status are being excluded. They often do have other resorts before they will be removed to a country where they might face torture or persecution or death. So there are other processes in place, but in terms of refugee process, they are not entitled to a refugee status in Canada and most countries around the world. Now, in both in Canada and a lot of other countries and the International Refugee Convention of 1951, have a provision that says you shall be given refugee status if you face persecution based on a number of grounds, such as political reasons, religious reasons, social reasons, you go to a social group, political group, etc. And then the convention says, but that shall not apply if you have committed one of the following three criminal activities. And the first one, and it's set out in Article 1F of the Convention, and the first one, there is 1FA, which Nancy will talk about, it says, if a person has committed a crime against peace, a war crime, or a crime against humanity, that person is not entitled to refugee status. Now, those three crimes are the most serious crimes known at the international level. If you commit those kind of crimes, you are definitely a persona non grata, legally and also sociologically. That is 1FA. 1FB, which I will discuss in some more detail, says a person who has committed a serious non-political crime is also not entitled to refugee protection. And I'll talk about 1FB. There's a third one, 1FC, that neither Nancy and I will talk about, and there's nothing about it in the book either, is if somebody is guilty of an act against the principles and purpose of the United Nations. And by the way, we will talk about it, that exclusion ground is so broadly worded that judges and decision makers have had great difficulty in actually defining what it means. It has not been applied very much compared to the ones Nancy and I will talk about, 1FA and 1FB. A bit more about those three exclusion clauses before I start delving into the 1FB one, this is my chapter, is that if 1FA says if you commit a crime against peace, a war crime, or crime against humanity, as defined by international instruments. So it's not defined by a Canadian court, as defined internationally. And there are international instruments that actually say what those crimes mean. So there's like some guidance from outside Canada that says how a court or a decision maker should interpret that. Same thing for 1FC, it says acts or principles of the United Nations. This has been interpreted very broadly. However, 1FB that I will talk about has no guidance whatsoever. It says somebody has committed a serious non-political crime, period. So, in my chapter, I examined about a dozen countries to see how they interpret every single aspect. What is a crime? What is a serious crime? What is a political crime? Those things were not defined internationally. There's no guidance there at all. And one conclusion I already drew from my analysis is that in spite of the fact that those are broad terms, despite the fact that the countries that I looked at, and I picked those countries because they have dealt the most with criminality. I'm talking about the United States, Canada, North America, a number of European countries, and Australia and New Zealand, and none of them, or very little, did they discuss each other's jurisprudence or each other's development of the law. It was developed by those countries very much in isolation. But even so, it's, in my conclusion, it's surprising that even so, of this kind of territorially approach, most decision makers and courts came generally to the same broad conclusions what a serious crime and brutal crime should be, which is, I think, very encouraging. And now there's much more interaction, much more discussion, and much more study of each other's legal systems in this area, so it's a bit better than before. And the second thing that I noticed, and I get to a conclusion there as well, is that even though we deal with inherently bad behavior, the way decision makers start interpreting 1FB, they started out with very broad concepts. They would give a broad concept of what crime means, what political crime means, and also what the word committed. Because committed is not only, in both 1FA, 1FB, and FC, not only a person who commits the crime individually, but also people who commit it as part of a group, or who support another person, the notion of complicity. And especially in complicity, 1FB was interpreted originally very broadly. So were things what is a crime. But as time went on, and it might be also reflected in Angus's presentation, you see that decision makers were starting to take originally a broad approach to those exclusion clauses, at least in 1FB, and the court starts saying, not so fast and not so far. They start drawing back, start interpreting the clause more narrowly over time. Which means that even though criminal behavior is regulated, the courts have said, but only to a certain extent. Keeping in mind, or they didn't say so, keeping in mind, we are dealing with refugee claimants. And even though they have criminal acts, it should not be an anchor around their neck for all time for behavior which might be criminal, but is not criminal in a very serious sense. So you see like a bit of drawing back by the courts over time. One example of that is, for instance, the notion of what is a crime. And it was especially in a context where various courts like Australia, the United States, Canada, and also the Netherlands and Belgium looked at how do you deal with a conviction for a crime a person had received in a foreign country and then comes to, say, Canada or Australia or the United States. You would think, logically, well, if another country convicts you, that should automatically result in an FB exclusion, because if you are convicted for a particular crime outside those countries, it must be criminal for 1FB. Keeping in mind, you do not the conviction theoretically. So you would think, well, foreign conviction is in a sine qua non, like you have a conviction, therefore you automatically become almost in the 1FB exclusion. However, courts have looked at where this conviction entered. And they actually go to an exercise what the foreign country did. Because don't forget, the people who are convicted for the foreign country are often the same people who came here because they faced persecution there. And you see courts in Western Europe and North America saying, well, the foreign conviction is, first of all, for a crime we don't even know. Like there was one crime, I think it was in France, about being aggressive while listening to a speech. Well, it seems to be more of a hallmark of a society that's a bit more repressive than ours. So they said, well, we do not know that crime, so we do recognize conviction. You see indeed that countries, West European and North American countries, will look at foreign conviction and make an analysis in how far the foreign country is actually similar to Canada in terms of the legal system, the type of crimes we have criminalized, and how serious those crimes would be in Canada. So they do draw a line there. Another example in how the courts have been looking at this area of crime is, what is a serious crime? There's no guidance, as I said. So there have been different approaches. One approach has been any crime that is grave. That is what's said in Germany and France. Like murder, rape, of course, is grave. There's no reason to further define it. Other countries said, okay, what would be a maximum penalty that crime would get in our country? If the maximum penalty is, say, more than 10 years, it's serious for purposes of exclusion for refugee standards. Other countries like Canada, and it's being followed more and more, said, well, no, wait a minute, that is kind of an absolute approach. We should look at the crimes committed and look for maximum, for what is serious, what was the purpose of criminalization? What penalties does it have? Does it have like a range of penalties, of maximum, minimum range? And also especially when a person committed a crime, what are aggravating and mitigating circumstances? Aggravating being, for instance, did a person use a gun while committing the crime of, say, robbery? If so, that goes towards being more serious. If not so, it might be less serious. Was the person using violence when using a crime? Like an aggravating factor. On the other hand, was the person while committing the crime under the influence or trying to support a drug habit? Those kind of aspects will be like look at whether make the crime less serious. So this kind of analysis has been used in Canada for a while, and so it's not an absolute way. What is, let's say, 10 years or more? Is okay, what kind of factors will contribute to make it serious or less serious? Which means that the starting point is still 10 years or more, but if a person committed a crime of that magnitude, but did it, say, under a form of compulsion, that will say, well, we don't find no longer a crime that serious, the person will be excluded. So there are more aspects, but I'm running out of time. So all this to say is that even though there's no guidance given by the International Instrument Refugee Convention, and even though a number of countries have been looking in isolation, you do see convergence of approaches and how it should be defined. And generally speaking, those approaches are being developed more to the advantage of the refugee claimant than was the case before. Thank you.
So I'm going to speak about, as Joseph said, complicity in war crimes, crimes against humanity. So what does that have to do with Canada? And what does that have to do with refugee determination? Well, basically, people who come to Canada from wherever, whatever country, and they claim refugee protection. They want protection in Canada to stay in Canada because they're claiming they have a well-founded fear of persecution based on political opinion, they're a member of a certain group, but there's something about what they did back in their country where it may be that they've committed a war crime or a crime against humanity. The thing is, most refugee claimants, when they come to Canada, they don't say, oh, by the way, I committed a war crime, I committed a crime against humanity. But what they do tell us is that I was a member of a group, and because I was a member of this group back in my country, if I were to go back to that country, the government is after me, and they're going to persecute me. And so that's why I have to be in Canada, because I am fleeing persecution. I want to be protected here in Canada. And we say, well, what about that group? Well, what group were you in? And they tell us, and we say, well, we have documentary evidence here that that group or people in that group have committed war crimes and crimes against humanity. It could be a private organization, like maybe a terrorist organization, or it could even be a national organization like a military. As you know, in history, we've seen, even going on today as we speak, there are militaries that are persecuting civilians. And so we may not have direct evidence that this refugee claimant has actually committed what we know is a war crime or a crime against humanity, killing or harming or torturing other civilians. But they were in a group, whether it was a military or a terrorist organization or some other type of private organization, not linked at all to the state, where we have documentary evidence from Amnesty International, from Human Rights Watch, that says that people in that group have committed war crimes and crimes against humanity. And as Joseph said, those people, even if they have a well-founded fear of persecution, so they fit the refugee definition, and they would but for their participation in that group, they would be entitled to protected person status. Canada isn't giving them protected person status because, as Joseph said, they'd be excluded from protected person status. Not because they directly participated in a war crime or a crime against humanity, but they were in that group and they did something significant enough with knowledge and not under duress to say that they were complicit in a war crime or crime against humanity. So for the last 29 years since its inception, since 1989, of the Immigration and Refugee Board on refugee determination, the board has been looking at these issues. We generally don't get people who are direct perpetrators, people who have actually pulled the trigger and killed civilians or tortured civilians. We generally don't get people like that. If we do, they're not admitting to it. But we do get people who are saying, I was in this group, I was in this military, they're going to persecute me in my home country because of my participation in that group, and therefore I need protection. But it's possible that we may find that they're complicit, and basically that's what we've been doing for the past 29 years. But a number of years ago, this issue of complicity, who's complicit? Somebody who is not a direct perpetrator, but somebody who's complicit, and if they're complicit, the way the exclusion clauses work is that they're as responsible as the person who pulled the trigger. And what that means in terms of refugee determination of the board is that they don't get refugee protection. Now, there was a test that was developed from the courts and the board for many, many years. Finally, this issue went up to the Supreme Court of Canada in 2013 in a case called Issaquah. And the Supreme Court of Canada said, when we're looking at this notion of complicity and people who aren't entitled to refugee protection because they may be complicit in war crimes and crimes against humanity, we're not going to just look at our jurisprudence here. We're going to look at the international case law and how has this issue been dealt with elsewhere. And so the court said, we need a rejigging of this test. Because it shouldn't just be somebody who associates with a group that should be denied refugee protection, excluded from refugee protection. It should be something more. And in fact, this is what the court said. The court said, some of the world's worst crimes are committed often at a distance by a multitude of actors. But there needs to be a rejigging of this test for those kind of people to bring it in line with international law. And so they developed a new test. So this test isn't for people who actually pulled the trigger or committed an act of torture. This is for people who are in a group. There's no evidence that they themselves personally committed a war crime. There is no evidence that they actually tortured somebody, but because they were in this group and they were involved in some way, you apply the test and you determine if they're complicit, then they don't get refugee protection. So the question for the Supreme Court of Canada was, what should be the test? What makes some type of participation in an organization to such an extent that we're going to deny these people refugee protection who, but for that, would fit within the refugee definition? So the Supreme Court of Canada said, looking at in international law, they said there's three main elements that refugee board you need to look at when you're determining who gets excluded for participation in organizations and therefore don't get refugee protection. So let's think in terms of either a terrorist organization, a private organization, or an organization where the state is involved, like a military that is involved in persecuting its citizens and torturing its citizens. So if we get somebody who was a soldier, a former military person, where we have documentary evidence that that organization, that the other soldiers have committed torture against its own civilians, and now we have a soldier in front of us, what should we look at to determine whether we're going to deny refugee protection from that person. The court said you need to look at three main elements. The first is you need to make sure that their participation in that organization is voluntary, that they did it voluntarily. So we look at whether somebody was conscripted. And if they weren't conscripted, if they joined voluntarily, maybe they couldn't get out after a while. So their participation during that time in that organization that was committing war crimes and crimes against humanity, their participation has to be voluntary. The second thing is that it has to be a significant contribution. Now, they couldn't sort of give an example, the Supreme Court of Canada, of every single type of significant participation in an organization. So what they did was they gave us various things to look at, various factors to determine what is significant. So imagine a private in a military who was given orders to be involved in the field and was conscripted. When that person comes here and says, I can't go back there, like El Salvador, during the time of the Civil War in El Salvador, the person said, I can't go back because I was in the military and we were involved in various things, and if I go back, I'm going to be persecuted by the government. Because of the government, let's say, changed hands, I'm going to be persecuted. So we look to see, well, okay, so you were a soldier in the military. How did you get into the military? Was it voluntary? What did you do while you were in the military? What was your involvement? Because in order to be excluded, in order to be denied refugee protection here in Canada, whatever they did in that organization towards the war crime or crime against humanity, towards the crime or the criminal purpose of the group, has to be significant participation. So it's not going to be that every soldier, every private in the military where there's evidence of crimes against humanity, not every single one of them would be excluded. And the last element has to be knowing contribution. So there has to be evidence that they knew that these things were going on. So you might say to yourself, well, somebody might just come here and say, well, I didn't know. But yeah, I was in the military for 5 years. And I understand that there's documentary evidence and I was in this particular area, and the documents say that soldiers in that area were committing torture against civilians. And yes, I was in the field, but I didn't know. And so then it's up to the refugee board to determine whether that's true or not. And they may be able to infer knowledge. So those are the main elements, and that's why the court established this new test, is that it has to be voluntary, it has to be significant, and it has to be with knowledge. So basically, you have this new test, and then the board had this new test, and the board had to apply it to fact situations. So I'll just give you one example where the board looked at the particular fact situation and said, because of this person's participation in this particular ministry of the government, they're not entitled to refugee protection because they're complicit in crimes against humanity. And this was somebody who actually, the claimant came to Canada claiming refugee protection, and he was from Burundi, and he was a civil servant of Tutsi origin. And he was actually the district chief in the Ministry of the Interior during the time that we had evidence that there were commission of crimes against humanity against Hutus. And so this individual was the district chief in the area where these crimes against humanity were taking place. So the court looked at it, the board first looked at it, and the court looked at it and said, well, he voluntarily became the district chief. It was significant participation because he oversaw people who were involved in these types of crimes. He had people under his command. There may not have been evidence that he ordered people to be killed or tortured, but he was in charge of those people. He could have done something to change things. And so the court basically said that kind of person was complicit because they had the power to intervene. Their participation was significant. They weren't like a lowly private. They were the district chief. They could have done something to change it. They had knowledge. It was a significant enough contribution, not to the particular crime. There was no evidence that he had actually himself tortured civilians or killed civilians, but people under him had. And there was a close enough connection to say, you're complicit. And if you're complicit, you're as guilty as the people, in terms of refugee protection, you're as guilty as the people who actually pulled the trigger or tortured. And therefore, you're not entitled to refugee protection. And he wasn't. He wasn't given refugee protection, and he was excluded. And this was all based on this new test in Issaquah. So there's several other cases over the years since 2013 where, for the most part, the board has applied this definition and has been upheld by the courts in denying refugee protection for those type of people. But the Supreme Court of Canada really set a much higher bar because, after all, people are coming here to claim refugee protection, and if they have a well-founded fear of persecution, they're entitled to protected person status, unless there is this significant and knowing contribution to a war crime or a crime against humanity.
Okay, I will be very brief because I didn't even really know that I was going to be here today until last night, and so I literally wrote a couple of notes on a napkin. First of all, I just wanted to thank James, first of all, for the tremendous amount of work that goes into shepherding a book project like this from inception to finalization. It's I appreciated from afar how much he and Dilatak were doing to make this book a reality, and I think it's a really helpful contribution to the whole area of immigration enforcement, and to this area that we now call crimmigration, which is this kind of merged zone between criminal law and immigration law. Second of all, I just throw out what I think is probably self-evident to all of us here, which is that this is really one of the defining moments of this era. I defy really anyone to open up a newspaper really on any day of the week and not be able to find an article on immigration regulation, refugee policy, and the limitation on rights to seek refugee status, on the criminalization of acts to attempt to seek refugee status, and on the aims of countries throughout the world to control the movement of people. It is as relevant in Europe as it is in North America. It's relevant in Australia. It is this very live issue right now. And I think nothing actually illustrates that more than the fact that the topics that Nancy and Joseph and I all wrote about in this book all came in this one moment over the last 5 years before the Supreme Court of Canada in 3 different cases. So Nancy just spoke about this case called Issaquah, which really helped to elaborate this idea of complicity in war crimes and crimes against humanity, and that's related to this Article 1FA of the Refugee Convention. Shortly thereafter, there was another case called Feblas that came before the Supreme Court of Canada that dealt with the whole issue of when non-political crimes will essentially cancel one's right to seek refugee status. And in the paper that I wrote for this publication, I wrote about the issue of people smuggling. It's a pretty vexing issue. The courts have a very hard time defining who is a people smuggler versus who may be a humanitarian who is assisting refugees in asserting their right to seek refugee status. And that came before the Supreme Court of Canada most recently in a case in a companion of cases, one called B10, was a numbered case, and the other dealt with criminal law. So I'm going to talk about both of those things. But I guess I'll begin by going back to what I briefly spoke about, which is this difficulty in defining what people smuggling is. We all know about kind of the iconic behavior of what we imagine to be a people smuggler, someone who, kind of in a usurious way takes money to help people transcend and cross borders, and that is an illicit activity. It is a criminalized activity under international law and under Canadian law. But there are other instances where it's less clear. And so at international law, there is a clear and sharp dividing line between what is people smuggling and what may be another act of assisting someone to cross a border that is not actually an act of people smuggling. Under a different UN convention, the UN Convention on Transnational Organized Crime, that convention has a couple of different protocols, one of which is on people smuggling, one of which is on human trafficking, which I'm not going to talk about today. But people smuggling, the protocol on people smuggling, really separates out who is a smuggler and who is not by whether or not that individual is obtaining a material benefit, a profit from that smuggling process. And I think that makes a certain amount of intuitive sense. That having been said, the Canadian law that prohibits people smuggling as a criminal offense didn't make that distinction. And I'll get back to something that Joe said at the very beginning of the talk, which is that we kind of imagine criminal law to be contained in the Criminal Code of Canada. And if it's not there, it's some other kind of regulatory law. But that's not always the case. They're not airtight systems of law. So under the Immigration and Refugee Protection Act, which is our main law for regulating immigration law, there are many provisions that provide the nuts and the bolts about how people may immigrate and what happens when people don't do it pursuant to the law. And those are kind of administrative regulatory provisions. But there are other provisions in the Immigration and Refugee Protection Act that are criminal prohibitions, one of which relates to people smuggling. So at Section 117 of the Immigration and Refugee Protection Act, you have a provision that criminalizes people smuggling. It does not and did not make this distinction between those who seek profit and those who may help people for other reasons. And this all came to a head in Canada. You might recall that in 2009 and 2010, there were some migrant ships that arrived off the west coast that had mostly entirely Tamil asylum seekers who were fleeing the civil war in Sri Lanka. The government of the day decided to respond to the arrival of these ships quite aggressively by finding that some of those who were on board the ship were inadmissible to Canada because they had engaged in people smuggling, and prosecuting some under criminal law, the criminal law in the Immigration and Refugee Protection Act, saying that they had actually committed a criminal offense in facilitating the journey from Thailand as it originated to Canada. And so this kind of trickled up through the courts, these cases, and they all ended up at the Supreme Court of Canada in these cases that looked at both how you define people smuggling under just regular immigration law and how you define people smuggling under criminal law. And essentially the court found that the Canadian law, the Canadian criminal law was overly broad because it didn't contain this qualifier that smuggling is really smuggling only when there is some kind of benefit that accrues to the smuggler. And so it found that it violated the Charter of Rights and Freedoms and read it down, essentially. It didn't strike down the provision, but it said that essentially when Canadian prosecutors, RCMP, when people interpret this people smuggling provision, they have to do so by recourse to the question of whether or not this was a profit-making enterprise. There was any benefit to the individual. A benefit doesn't have to be, a handsome financial profit. It can be any number of things. But there has to be some motive of profit, some motive of gain for people smuggling in this sense to be people smuggling. So I wrote about that in this chapter, and I wrote about how it's also been interpreted internationally, and there's been some controversy over whether or not that profit motive is actually integral to the definition of people smuggling or not, and I elaborate on that here. But I guess I'd say just as a plug to the book generally, and I'll end here, I'll go back to what I said before, that this really is an issue of immense importance both in Canada and internationally, and I think its relevance will really kind of withstand the test of time as we move forward through the next couple of years, where I think this issue isn't diminishing, but may in fact actually increase. So I'll leave it there, and of course I think we're all open to answering questions.
You mentioned for people smuggling that there should be this category that someone who wants to have humanitarian help, that's in a different category than someone who gets material gain. Shouldn't there be a third category where someone may think they're doing humanitarian assistance, but may be placing these refugees or potential refugee claimants in such great danger that the danger, say, in going in one of these unseaworthy vessels and sinking, that is probably more dangerous than having these people stay in the bad situation where they are. I'm thinking of, say, ships crossing the Mediterranean or going from Thailand to Greece. I would think that if there's someone who does something like that, maybe Bolton may keep that criminal. Do you have any comments on that?
Yeah, the court considered a couple of different scenarios that the government put to it, which suggested that the whole profit motive might not entirely capture the range of motives that we might want to criminalize. So the kind of hypothetical they put forward was those who may assist others, not for profit, but say for terrorist reasons. You know, it may be ideological, the reason why they are assisting someone else across a border. And so the argument of the government was we have to have a broad enough range, a broad enough interpretation of people smuggling to capture these other kinds of scenarios that may arise where we want to criminalize the assistance that others provide to individuals in crossing borders. And the response to that from the court was essentially there are other tools to do that with. So if you could commit a criminal act or going back to the terrorism example, if you are assisting someone in traversing a border in order to commit a terrorist act, we have other provisions that very clearly and broadly capture that. And I think that explanation could also provide an answer to your specific question, which is that if the way by which someone assists someone to cross a border is in itself a criminal act, separate and apart from the whole smuggling piece, Canadian immigration law has mechanisms by which to address that particular situation. But I think it's a good question. The only other thing I'd say about that is that, you know, and I am speaking not in my current capacity as a member of the Immigration Refugee Board, but just kind of more broadly as a policy discussion. I think the whole question of people exercising their own agency to cross a border to seek their protected right to seek asylum, and the fact that they may be willing to undertake incredible risks to themselves to assert that right, and it's a right that is protected by international law, is a global policy failure. It's one that goes far beyond, I think, just, you know, individual cases where smugglers who are clearly acting in extremely immoral ways in exposing these individuals to risk. Yes, they are doing that, and that needs to be addressed on a case-by-case basis, but there's a larger context, I think, as well, that needs to be discussed.
Here in my act, to a specific example of a people smuggler utilizing like a ship that is so unseaworthy that it's foreseeable that people will die or will be injured. That, as Angus said, can be addressed in our provisions, including the chapter I read about 1MB, and there have been cases outside Canada. In Australia, there have been two cases whereby people smugglers were found to be excluded because they were using dangerous methods to bring people into Australia, and they were found excluded on that basis. And as again, as Angus said, is like you could use criminal principles saying, well, he did not intend to say kill a person, but if you are negligent in equipping a ship that is foreseeable that somebody might die, then, or what happened, say, in the case of the two boats here, that the crew actually abandoned the ship and left the people who were being smuggled to try to get the ships here. If you get the people who abandoned the ship and put the people being smuggled in such dire circumstances, you can use criminal principles to find them not to be refugee and be excluded. And one thing that I mentioned in my presentation on FB, there's one aspect that is also in FB, is that you have to commit the offense outside the country of refuge. And Australian courts got around that because the people smugglers, they actually ended up with the ship in Australia, so it did not happen outside Australia. They dealt with it saying, well, actually, you started outside Australian waters, they happened to end up inside, so we're only going to use exclusion for the period you are outside Australian waters when those bad things happen. So yes, there definitely are mechanisms to deal with people smugglers who do not treat people being smuggled in an appropriate way.
I have a short comment. Let's indict and criminalize those officials who wanted to make regime changes in Iraq, in Libya, in Syria, because as we know right now, the immigration crisis that we have in the Mediterranean, in the Middle East, it started with the regime change. So let's criminalize the officials who made these activities in the first place.
You mean like al-Bashir?
No, let's criminalize the United States government. For example, we know that Hillary Clinton was crucial in regime change in Libya. We know who instigated regime change in Iraq. We know who supported the rebels, the so-called moderate opposition in Syria.
Okay.
We know all that. So let's criminalize those government officials in those countries. Because it is a direct relations. It is a direct cause of this criminalization.
You want to answer, or you go straight by?
I'm going to leave that one alone.
Okay. I'm retired, so I can actually answer. I did this 2 years ago. This is, of course, partially a political question, and that doesn't bother me either. If you make the example of Libya, first of all, the regime change was against a person who was widely considered to be desperate and actually a person who caused a lot of suffering, Gaddafi. Right? So that was the reason why the United Nations Security Council said we are authorize the international coalition to go in there and first of all get rid of Gaddafi, and secondly, what happened was the council had a resolution saying we see evidence that Gaddafi is about to slaughter a large population in one of the coastal cities. We have the authority to try to prevent that. It's called RP2, the right to protect a population. So they authorized, first of all, for NATO to go into Syria to prevent an atrocity from happening by the existing regime. And secondly, they also authorized for the International Criminal Court to actually indict and prosecute Gaddafi. He died in the process, so they stopped indictment. So that is one part. To your question, whether or not there are mechanisms to deal with people who are at high positions that cause this kind of stuff, like Gaddafi, like al-Bashir, like Saddam Hussein, those mechanisms exist currently. The main is the International Criminal Court, which has indicted Gaddafi until he died, and they're also looking at al-Bashir. But it is theoretically possible to also indict on the international criminal law people who assist, like even Saddam Hussein or al-Bashir, in carrying out those monstrous activities. Legally and technically, whether it happens, you completely in a vertical realm. And that's a different question. I mean, for instance, the ICC International Court has gone as far to investigate the situation in Afghanistan, and they have, the prosecutor is looking at investigating everybody who played a role in Afghanistan till about, I think, 5 years ago. Afghani government, Afghani opposition parties, the Taliban, and the Brits and Americans. They sparked the investigation. What happens? John Bolton a month ago says, if you dare to indict an American, we will take action. As a matter of fact, there was something called in the United States called the Hague Invasion Act, where the Americans have authority to actually use force to liberate an American soldier being held in the jail of national court. It's authority to do that. So what I'm saying is, it is technically possible, but you run head on into like a political wall, and it's not being helped at the moment by a number of populist regimes who take a very, very isolationist approach rather than an international approach. So I agree with you. The people who convey this kind of misery should be held responsible. There's more and more happening right to the top head of state. It's also possible people who helped. I mean, there's a traditional case called Nicaragua, where it was actually on TV the other day, whereby the American government helped the Contras to defeat the Sandinista government. And International Court of Justice looking at how far can you hold Americans responsible to international law. It said it's possible if you do a number of requirements, which is not possible in a particular case. So there are mechanisms, but unfortunately, you do international institutions, international law, it's so politicized that you have the principles and you can apply them technically, but you're not, like for instance, to investigate the Americans, there's no way the American government is going to help you. So how are you going to get the evidence? So you really run into practical and political obstacles, which is really unfortunate. I agree with you.
So you won't be able to indict George Bush because he's gone. I'd like to just ask you a question related to the European situation, and which is illustrated in a book by Jenny called Go and Come. And it deals with the situation of the North Africans that arrived in Italy and then ultimately moved to Germany. And there's a whole series of people there that are depicted. They're from places like Ghana, Sierra Leone, Niger, various places in Africa. And they have different reasons for claiming asylum. So I'd like you to just distinguish between refugee and asylum. And the consideration there in the book is that these people had nothing, they could go back, say, for example, Ghana, because there was no active war there, or there was no, it was a country that bureaucracy recognized as being a destination that you could return to in their estimations, despite the fact that these people, individuals, all like individual cases. And put that in context with the fact that Jamaicans can come here because they fear persecution from being murdered because of gangs. So it's a cultural thing in that situation. So what, could you just frame that, the answer in relation to the distinction between asylum and refugee?
Well, I mean, a couple of things. Canadian law, in a case from the early 90s called Ward, was at the forefront internationally, but has since been followed by most countries in recognizing that persecution as a definition under the convention, the Refugee Convention, can arise from state actors, the kind of idea of persecution that we tend to think of, like flowing from the Second World War, state-sponsored persecution, but can just as equally arise from non-state actors. And that's because the definition of persecution is really the failure of a state to protect its citizens on the basis of one of the grounds that's in the convention. And those are the grounds we think about, race, religion, etc., political opinion. So the Supreme Court in Ward said it's not just states that persecute individuals, but the other scenario in which people can be considered to be persecuted is when they face some kind of significant mistreatment in their country from which the state will not or cannot protect them. And that gets you into the category of who is a refugee, just as the more traditional kind of conception of refugee as someone who is persecuted directly by the state. So that's how we can have Jamaicans who fear persecution on the basis of their sexual orientation, just as we can have individuals who are fleeing from Syria because they have expressed opposition to Assad. In terms of who is on the boats, I mean, it's obviously a mixed question. There are many Eritreans on those boats who would clearly satisfy the criteria for being considered a refugee. But I don't know exactly how to answer that part of your question because as you say, that comes down to a case-by-case determination as to who these people are and why they've left. And as I said in my earlier remarks, people are entitled in international law not to refugee protection, but to an assessment as to whether or not they are in need of refugee protection. So if states are going to comply with that convention, then they have to provide some kind of mechanism for an individualized process to determine whether or not they come under the definition.
I totally agree. Like you mentioned, people from Ghana who might not face any consequences, adverse consequences upon return. There's no doubt that in the large number of people who are fleeing countries and coming to Europe or coming to Canada, there are people who are fleeing for economic reasons, that they have no reason to fear persecution. Now, Ghana is a funny situation because more recently there's definite people being persecuted because of the religion, the Christian minority in the north are being persecuted because they're Christians. But two aspects. So first of all, not everybody who claims refugee status is or should be entitled to it. That is why in Canada, most European and North American countries, we have, as Angus says, individual assessment. Every person who claims refugee status gets before the board, where Angus and directly Nancy work, and they have a chance to plead their case. And if the board member finds that, well, you don't make your case because they don't be persecuted, that person can and will be removed. And as I'm not mistaken, the acceptance rate is around 50% nowadays? Or higher, okay. So I was always to say, not everybody will get automatic refugee status. It will be individually assessed. Secondly, on the issue of, you mentioned the Jamaicans and maybe a cultural issue, a different cultural approach in Jamaica than we have here. Angus mentioned the Ward decision, the Supreme Court. One other thing that Ward said is that of those 5 groups in persecution, I don't know, 5, okay. One was called social group. It appears to me, not being an expert in this area, but social group is the area where you can fit in a lot of subcategories. I mean, religious, political is pretty well defined. Social group, over time in Canada, I think that the board issued a paper in, I think, 10 years ago with about 20 categories of what could be social group. And it's people for instance, women being abused by their husbands is part of the social group. Gays are a social group, a number of people. I think it's a great thing because that's where you can probably expand. So, and when we look at it, and again, correct me if I'm wrong, but we of course look at it from our Canadian standards. I mean, if you claim refugee status, it seems to me that Canadian cultural practices will prevail over people who from other countries because this is our society, this is what we represent. Now, I'm hoping not too controversial here in saying that. So I always mean, you are right, there's a whole bunch of people, and whether they're going to be accepted depends on why they are claiming persecution, and that should be assessed on personal reasons. But there's a lot of developments taking place in Europe and North America, how to fill out those general norms, those general groups of social burden, especially social.
Yeah, I recently went online and I don't know how I got there, but I was doing some of the work. And I saw all the decisions of the board, and they're listed in terms of the countries. So the figure you gave, 50%, was true in some cases. But I couldn't see, I couldn't look at those statistics, say for example, Nigeria, and get an idea as to what the board is doing. Like I mean, if I had a client and I was bringing them before the board, then I'd want to look at those statistics and see what my chances are in terms of where that person originated from. But
I think you have a better, what you could do as well, if somebody who wants to look to see how the board has treated different types of claimants from different countries, is that you could do a search to look at the various cases of the federal court to see also, I mean, you wouldn't look just at statistics of the board, but you'd also look to see in the federal court in review of board decisions, the success rate of different types of claimants, because it's not just the country, it's also the type and the nature of the claim. There's 5 grounds of potential persecution under the refugee definition. And then there's other individuals who might be entitled to refugee protection for other reasons as well. So it's very, very, as Angus said, it's very, very case specific. It's the country, but it's also the nature of the claim. So for example, you might look at statistics for acceptance rates in central region and of a country, and you might look at acceptance rates in another part of the country, say in eastern region, and you might think that there is a difference in the acceptance rates depending on the region. And in fact, what that really is statistics only go so far. You have to see, well, what is the nature of the claim? And so we've seen a differential in that. It may be the same country, but persons perhaps, and it depends on the country, but persons perhaps coming to eastern region, Montreal, a certain type of claimant is making a claim based on a certain ground. Whereas in Toronto, the exact same country, but the basis of the claim is something different, because maybe they're a different religion, they're a different ethnic background. And so that'll affect acceptance rate. So it's very, very case specific. But if you were interested, you really want to look, I would suggest even looking in Canley and looking to see at the different federal court decisions to see how the court has dealt with different types of claims in terms of accepting the decisions of the Refugee Protection Division.
I think the federal court decisions are digitized, I think.
Yeah.
Oh yeah, absolutely. Yeah, but if you look in Canley, or you'll be able to do a search in that respect as well.
Thank you.
I wonder if I could ask a question to the panel related to crimmigration. And I'm wondering to what extent Article 1F actually requires the merging of criminal law, whether it's international or domestic or national law, and immigration law. It forces the decision maker to apply these 2 different branches of law in terms of making a determination. The general criticism, and this might be an exception broadly speaking in terms of the general trend in terms of merging of the 2 branches of law generally in states, but I'm wondering, just from your impressions, whether that forcing under Article 1F still generates the kinds of criticisms that you see in the literature with respect to the merger of criminal law and immigration law, because criminal law over centuries has evolved certain protections of the defendant in terms of the rules of evidence, in terms of incarcerating someone without charges, et cetera, and we don't have those kinds of safeguards necessarily developed within immigration law. But given that Article 1F forces you to actually bring these 2 branches of law together, do you think that we've developed the jurisprudence and the standards that can allow us to make those kinds of decisions equitably, fairly, and justly?
Well, you know, it's very interesting because if you look, for example, just at Isicola, as I was speaking about, if you read through the entire decision, you don't see a lot about the intersection between actual domestic criminal law and criminal law principles with the actual decision and its application in exclusion from refugee protection or inadmissibility, which then results in denial of refugee protection. The Supreme Court of Canada and Isicola looked more in terms of the international jurisprudence as it relates to complicity in war crimes and crimes against humanity. And you don't see a lot of, well, we're going to borrow this from the criminal law context. We saw a little bit of it, but there was more of an emphasis on international humanitarian law and how the notion of complicity in war crimes and crimes against humanity is treated in the international context and international law. That's in terms of complicity in war crimes and crimes against humanity. Maybe Joseph can speak to 1FB.
Well, general exclusion, I think the debate you're alluding to took place in 1950 when they were negotiating the United Convention and whether or not to put in there a criminal exception and how broad it should be. There was an enormous debate, especially in France and the UK, about how F1FB should read. And UK was the view we should not have a provision based on very criminality, because it was not the case in the convention, the Universal Declaration of Human Rights. They also have an exception in 14.2. It says only guilty of international laws and principles. And Britain was very much opposed to putting 1FB in there, and France wanted very badly. Why? Political realities. France was like overcome with refugees. Britain had none. So they were quite easy to say, well, let's be principled about this, not have to deal with reality on the ground that France did. So eventually had a compromise. So I think since the debate took place in 1950, it has been acknowledged since that time that 1F is sort of taken out of the refugee debate with regards to criminality. It's not accepted. Criminality doesn't play a role in exclusion. Where the debate still takes place, I think, is in Rule 33.2, where you can remove somebody, even a person who can be prosecuted, if the person presents a danger to the security, danger to the public. That debate is still very much ongoing, both in Canada and in Europe. What does it mean to be danger to the public, danger to the community, danger to the security? In vague terms, that still is looked at, okay, how broad, how narrow should it be? I think that's where the debate takes place. In addition to how in immigration law, countries starting to criminalize more and more behaviors which are not, as I could call it, innate criminal. Right? So I think on 1F, that ship has sailed, I think, in terms of debate.
Yeah, I think a lot of your question does come back to Joseph's distinction between the domains where core, like criminal law acts, the idea, so like criminal acts that we think of as being criminal acts traditionally, have to be assessed against an immigration law kind of backdrop, versus the act of unauthorized immigration as being redefined as a criminal act. So those are two different things. So in the example of what we've been talking about, where you have acts like under 1FA or 1FB that are core criminal acts, yes, it forces decision makers into this area where, and it's often not in their comfort zone, right? Where they are immigration decision makers, but then then they're charged with interpreting some pretty complicated criminal law principles, and they're not always trained for that. They're not always able to do it with the same kind of expertise that a criminal court would be able to deal with it, and so you get problematic decisions that arise from that. But similarly, in criminal courts, where criminal courts are forced with dealing with immigration issues, you also get problems where criminal courts may proceed on an assumption about immigration consequences that may flow to an individual before the criminal courts that may just be wrong. And so you're always going to be in a bit of a danger zone when you're dealing with these crossover areas between criminal law and immigration law, whether that's in a core criminal law context or a core immigration law context.
So I just wanted to make one comment again about the book. You clarified one thing actually that was in the book. All those people that she depicts were returned to Italy. But getting back to your point, they all participated in a demonstration at Orientplatz. So I was wondering about that section 33. If you take part in a public demonstration, then it's not a criminal act, but you can get evidence. You can take pictures of people, and you can present that to the administrative tribunal.
You're correct. And then what would happen is someone would assess whether the public demonstration, well, first of all, and I won't belabor about me, it could even affect your status as a refugee, like because it's like refugee surplus. But in terms of like somebody being involved in a demonstration, some decision makers, some governments say, well, that makes you a danger to our community, a danger to security, a danger to the public. And at that basis, we can be allowed to join the international convention or international law to remove you. And that's a really slippery slope, because I think if you start infusing those terms with it's politically convenient at the time, it's not hard for a government to say in demonstration, you are a danger to our security. I think it's bogus, I think it's bullshit, but that is where you have now some governments in Eastern Europe and in the south of our border, that might very well be happening. Completely against, I think, the spirit of the convention, but again, it's becomes a political football. And the demonstration is a very good example. It should never be an aspect of a danger to security. It's part of everybody's universal right to demonstrate. But it's being used nowadays, and will be used nowadays by governments to push their agenda to. I think it would be an extreme form of criminalization of immigration, I think. So you're right, it would be terrible if it would happen, but I don't think it's unconceivable in the present world we live in.
Well, the CDU is having a convention this week to replace Merkel.
Sorry?
The CDU in Germany is having a convention, only 1,000 delegates to pick the successor to Merkel, and that's very much the debate.
But she's going to resign with them as well, right? Yes, she decides she's going to resign.
Not as chancellor, but as leader of the party.
Oh, okay.
So there's a convention of the party, CDU, I think it's on the 10th, next week, and it's very much at the center of whether they strengthen or harden that
Exactly.
Thank you very much for your presentations here today. And on behalf of McLaughlin College, I would like to present you with one of the most coveted items here at our college, and that you can only receive if you make a presentation here at McLaughlin College.
Thank you very much.
Please join me in thanking our speakers here today.